All right, Mr. Martone, are you able to hear me okay?
I can, Your Honor. Good afternoon.
All right, good afternoon. I don't see Mr. Traskos. Have you been in contact with him at all about the status conference today?
Well, sort of yes and no, Your Honor. I don't actually anticipate him attending, in part because he notified me late yesterday that he was actually having a surgical procedure performed this morning and was going to be out of the office today through the balance of the week and into early next week. Also, in full disclosure, because the parties had submitted a stipulated order extending the dates back in December, I don't know if Mr. Traskis believed that today's hearing was going forward. Or not. And so I had emailed him today asking if he was intending on having someone appear, and I have not heard back. So in fairness to him, if the court was inclined, I'm happy to pick another date that may be also convenient in light of his medical procedure.
Okay. All right. So yeah, I am looking at that stipulation to extend. That makes sense. So let's see. What's the current 75 days? So if I set this for another status conference in March, do you have any objection to that?
No, I would not, Your Honor.
Okay. Okay. Anything else that you wanted to state for the record today?
Not at the present time, Judge.
Okay, thank you. That's all for today, and thank you for appearing to kind of enlighten me on what's going on. I appreciate that.
Not a problem. And Happy New Year, Your Honor.
Okay, thanks. You're free to
Yep.
disconnect.
Thank you. Bye-bye.
Oh, Mr. Isles.
This courtroom moment turned tense when one lawyer attempted to remove another attorney from the case, claiming a serious conflict of interest. The judge listened carefully, reviewed the waiver, and examined the prior relationship between the parties. In the end, the court found no real conflict, no unfair advantage, and no reason to interfere with the client's right to choose their own lawyer. The motion to disqualify was denied.
All right, looks like we have everybody connected, so we'll go on the record in Crystal Gentz representing the estate of Cynthia Smith versus William Smith. This is file number 25118-329. And if I could have everybody put your appearances on, please.
Dave LaBella on behalf of the defendants, Your Honor. Good morning, or good afternoon, Your Honor. Timothy Dine appearing on behalf of Mr. Giroux in this matter.
And Scott Isles on behalf of Crystal Gentz, as the executive of the estate of Cynthia Smith.
All right, Mr. Giroux, did you want to put your appearance on as well? Your listed counsel in this case.
I don't know if you can hear us.
Mr. Giroux, are you able to hear me okay?
Want me to call him, Your Honor?
Yeah, I think so. I'm not sure he was connected there.
We can see you, we can't hear you. We're trying to talk to you to have you put your appearance on the record. Okay.
So he needs to connect his microphone.
Connect your microphone. Right,
Is he able to, what did he say?
he's gonna connect with us.
Okay. There we go. Okay, Mr. Drew, are you able to hear me?
Yes, I am.
Okay, great. Can you just put your appearance on for me, please?
Certainly. May it please the court, Robert Giroux appearing on behalf of the plaintiff, Crystal Gens, as personal representative of the estate of Cynthia Smith.
Okay, thank you. We're on the record today for a couple of different matters. We have 3 motions up from the defendant, and then we also have this set for a status conference today. I did have a chance to review the motions and response. And so I guess I'd like to just start with what I view as the most substantive motion here, which is the motion to disqualify Mr. Giroux. So Mr. Lobello, did you want to present any oral argument in support of that? I guess when I first saw the motion, I mean, I've been on the bench for 13 years. I've never had a motion by an attorney to disqualify another attorney. I always thought that those were matters within the scope of the Attorney Discipline Board and Grievance Commission. If an attorney had violated the rules of professional conduct in some way, that was something outside the scope of what the court would do. So I was a little surprised to even see this as a motion. But I obviously I read the authority that you cited. Was there anything you wanted to state in terms of oral argument in support of that?
Well, Your Honor, I'll be brief because the court has read the submissions. I think maybe striking at the heart of the matter here is that there is a waiver from Ms. Gens, as well as my client, Mr. Smith. I wasn't consulted or made aware that Mr. Smith was communicating with Mr. Giroux. But even if the court finds that the waiver is valid, the circumstances in this case are such that I cannot convey or talk to my client and convey my thoughts and mental impressions to him without fear of it being suffused, so to speak, to the other side, which impairs my ability to do my job. Ms. Gens and the estate are adequately represented by Mr. Isles in this matter. It's obviously their prerogative to hire as many attorneys as they'd like. Same for Mr. Smith, but as far as the administration of justice in this case goes, Your Honor, I believe that disqualification is necessary. And as the court cited, this is a matter that is properly before the court. This is not anything that's brought before that I've brought before the Attorney Grievance Commission in that regard, simply limited to the nature and scope of what the issues are here in this case.
All right, and so who's going to argue this on behalf of the plaintiff?
Your Honor, I'm going to be arguing on behalf of Mr. Giroux, if that's if the court approves of that.
Okay, yep, and I have no problem with that. I just want to state for the record, typically when I have multiple counsel in any given case on any issue, I do only allow one attorney to argue a motion. So Mr. Dinan, if you're taking the reins of this one, just so everybody's aware, I would only hear argument from Mr. Dinan on it, not the other 2 counsels. So as long as you guys are all okay with that, Mr. Dinan, you can proceed.
Thank you, Judge, and thank you for taking the time to review the pleadings. Really, this is a few issues exist here. The court perceives correctly that it's a client's prerogative to hire their counsel of choice.
Mr. Giroux built up a good relationship with William Smith when he first provided services to him right after the accident in 2022. My client is an expert on practicing personal injury law. He is a seasoned trial lawyer and someone that Ms. Gens found to be a great choice to be on the team to pursue the claims that she has in this matter. Your Honor, the court is going to need to look at this matter from from the standpoint of the freedom to contract who a client wants to hire, and then yes, there is an appearance of a conflict of interest. So the conflict would arise on its face because Mr. Giroux represented Mr. Smith at the time of the accident in a limited capacity. He was present for a statement under oath, and he helped him prepare forms. There was no criminal action that arose out of the accident, and there was no other lawsuit that was ultimately filed on behalf of the estate where Mr. Giroux had any further action. Ms. Gens approached Mr. Giroux to represent the estate for the purposes of trying the case if that was necessary. So the thought is that first, is there a conflict on its face? Yeah, it would appear to be a conflict on its face. The second question is it directly adverse to the interests of Mr. Smith to have Mr. Giroux represent the estate? And the answer to that question is no. First of all, Mr. Smith is in the unique position of being the former husband of the late Cynthia Smith, and also the stepfather of Crystal Gens. And in that regard, he has interests that he'd like to see prevail. The fact that counsel can't speak with his client openly and frankly, that problem would exist anyway because there's this affinity between Ms. Gens and Mr. Smith. So I believe this is a matter where it was necessary to get the proper waivers, which were executed and are part of the exhibits to my response to the motion. And there's really no demonstration of how or what information that Mr. Giroux would have that's not already part of the public record, and that the insurance company and Mr. Smith's counsel don't already have. So I don't think it would be appropriate to tell the estate who they can't have as their attorney in this matter. And I think it's advantageous, too, that Mr. Giroux would bring in previous knowledge of the case that would be helpful in the prosecution of it. Finally, Judge, it's Mr. Smith's prerogative to waive that interest, and he did so appropriately in a form that would be approved under the court rules.
Okay, thank you. Mr. Lovello, it's your motion. I'll give you an opportunity to respond to any of Mr. Dinan's arguments.
Well, Your Honor, I think Mr. Dinan hit it on the head as far as Mr. Giroux's ability to bring in previous knowledge about this case and its prosecution, which I think just goes more towards the fact that this is a wholly adverse relationship here, on top of the fact that I'm not aware that Mr. Smith has terminated Mr. Giroux in terms of his representation. So the air of Mr. Giroux representing the estate and Mr. Smith potentially exists because I haven't seen anything and I didn't see anything in the responses that the termination or the representation has ended between Mr. Smith and Mr. Giroux. So, with that, Your Honor, I again just go towards the scenario of how this plays out in trial if we get to that point, is that, Mr. Giroux potentially has information from Mr. Smith that isn't divulged to me or, is somewhat of a surprise due to the prior confidential relationship or the existing confidential relationship. I certainly have no ability to control what my client says to his stepdaughter about the case, and certainly it's not under any sort of ethical rule in terms of their communication. But I think the problem in this case here is patent, Your Honor, and we move for Mr. Giroux to be disqualified.
All right, thank you. So I did have a chance to, again, look at the law that was cited by both the parties in this case. And to go over the briefs, the arguments of counsel here are pretty consistent with the arguments that were made in writing. I do think there's two issues here. Number one, there's the waiver by Mr. Smith. I had a chance to look at that. It was attached as an exhibit. It does appear to be a proper waiver of conflict that was signed by Mr. Smith. It indicates, and the court has no reason to believe otherwise, that Mr. Smith indicated he had an opportunity to consult with counsel, whether that was Mr. Lobello or not, had an opportunity to consult with counsel before signing that waiver. And the fact that Mr. Lobello may have come in later, or that Mr. Smith, if Mr. Lobello was involved at the time the waiver was signed, that Mr. Smith made the decision on his own not to consult Mr. Lobello, I think isn't a burden that's borne by the plaintiffs in this case or by Mr. Giroux. I think that's a decision that was made by Mr. Smith of his own free will, and I think it would. There's no suggestion that was somehow improperly influenced or done without some kind of full disclosure to Mr. Smith, who is the one with the right to either waive or not waive that conflict, not his attorney or anybody else. So I think the waiver is a significant hurdle in this case. I don't find any reason to invalidate the waiver. And so for that reason, I don't think the court even needs to go into the other arguments or further analysis. We've got a proper waiver, and I don't think for that reason Mr. Giroux should be disqualified. However, even if we do look into the merits behind it, it's clear to me, and I don't think it's been contested, that there was very limited representation by Mr. Giroux earlier on with regard to Mr. Smith, that there wasn't any information disclosed to Mr. Giroux that wouldn't otherwise be available through documentation. And certainly Mr. Smith can discuss anything that he has discussed with Mr. Giroux, with Mr. Lobello, and make Mr. Lobello aware of all of those things as well. So the court doesn't find that there's enough of a conflict there to warrant what I view would be a fairly extreme step of, as indicated by the plaintiff here, of forcing the plaintiff to get a different counsel. So for those reasons, the court finds that there aren't grounds in the context of this litigation to disqualify Mr. Giroux. Now, I do want to state for the record that, obviously this court does not sit as the Attorney Grievance Commission.
In over 13 years on the bench, the judge admitted he had rarely seen a request like this. A lawyer tried to disqualify opposing counsel mid-case, arguing ethics and confidentiality concerns. But a valid waiver, limited past involvement, and publicly available information changed everything. The judge ruled that strategy alone isn't enough. The law must support the claim.
The rules of professional conduct and the ethics opinions that have been issued over the years. And while some were cited to the court as part of this motion, certainly not part generally of this court's practice or research. So I'm going to state for the record that I take no position, and this ruling should not be interpreted later on as any kind of finding that there absolutely would not be a violation of the rules of professional conduct by Mr. Giroux's continued representation of the plaintiff in this case. I would leave that, again, to the discipline board or the grievance commission later on, to the extent that anybody files an action in that to make that determination. I'm simply making a legal determination as a matter of law in this case that I don't find that Mr. Giroux should be disqualified. And the wisdom, I'm not going to speak for Mr. Giroux. He's a very experienced and very professional attorney. But I think everybody's proceeding at their own risk here, and it seems like, given the number of qualified counsel here, it may be a risk that nobody really needs to take. But again, that's not for me to determine. So all of that having been said, I return back to my original ruling, which is the court will deny the motion for disqualification. And so I would request, Mr. Lavelle, that you prepare an order reflecting that ruling to the court for the reasons stated and submit that under the 7-day rule. And then Mr. Labello, your next motion was a motion to amend the scheduling order. And Mr. Dinan, I'm assuming, are you going to kind of back out now that your part is done?
Yes, Your Honor. I was hoping you were going to ask. I wish you all very well, and thank you for your time this afternoon.
All right, thank you. So Mr. Drew,